coming up.
Mr. Dominic Barton chaired the Prime Minister's Economic Advisory Council, which started in 2016. And shortly after, interestingly coinciding with these dates, we see a 2,500% increase from 2016 to 2023 in contracts awarded to McKinsey.
If the exception becomes the rule, then I believe this becomes the culture and that we have a huge problem within the government. How is this allowed to happen with no consequences?
Their mandate is also to refer criminality, should you suspect criminality, to the appropriate authorities. And I believe you indicated when a question was put to you whether you discovered any element of criminality. I want to confirm a couple of things. Your threshold for referrals is based on suspicion and suspicion only. Is that correct?
What can be done to get at this core issue of maybe governments paying lip service to recommendations you've made, but then not taking their implementation seriously?
This guy's garage. Like and subscribe.
Which sheds even more light and I believe confirms even further the thoughts and ideas we had around contracting in the public service, both in adherence to the rules as well as a favoritism towards McKinsey. Madam Auditor General, last week I asked you to inform the Public Accounts Committee the date the 3 Canada Infrastructure Bank contracts were signed with McKinsey. Do you have those dates with you today?
I'm just going to turn to Nick and he can provide that to you.
Thank you.
Yes, we do. Just give me a moment to pull it up.
Maybe you want to move to your next question, or do you have it?
I have it,
Okay.
yeah.
Okay.
25th of January 2018, 30th of March 2018, and 19th of May 2020.
Okay, 19th of May 2020. Very interesting. Okay, thank you. Madam Auditor General, Mr. Dominic Barton chaired the Prime Minister's Economic Advisory Council, which started in 2016. And shortly after, interestingly coinciding with these dates, we see a 2,500% increase from 2016 to 2023 in contracts awarded to McKinsey. In your opinion, is it a conflict of interest to have the global head of a company also chairing an economic advisory committee that helps determine the direction of a government?
I mean, that's a difficult question for me to answer. I'm not sure in what capacity he was providing advice as the chair of that committee, what his requirements were. So I unfortunately can't offer up an opinion on that.
Okay, thank you. I'll return to a theme I mentioned in my opening comment, favoritism in contracting. McKinsey received 2 contracts with IRCC for close to $25 million. And it's from these contracts and the Economic Advisory Council, chaired by Mr. Dominic Barton, that led to the infamous 500,000 immigration target that this government is now walking back from. How dangerous is it for a company to chair an advisory council that sets policy in an effort to help its own interests, would you say?
Again, I'm sorry, I don't know much about what that committee was doing, so it would be inappropriate for me to provide thoughts or opinions on it.
Okay, thank you. There were 4 instances in the competitive procurement process where your office found that the procurement strategy was changed after departments learned McKinsey could not bid under the original circumstances. And unfortunately, to no one's surprise, McKinsey won the bid under new criteria. Can a department call it a competitive process when they are changing the requirements to cater towards one specific company, in this case, McKinsey and Company?
So in the case of the 4 contracts that you're referring to, there were 2 where there was a change in strategy. And while the federal government is able to change its procurement approaches as it goes about, I would have expected to see a justification on file as to why they made such a switch. And then because 2 contracts were awarded in a non-competitive way, clearly documenting why McKinsey would have been the only bidder or what exception was being used from the procurement rules. to award a contract non-competitively. And as we mentioned, more than half of the contracts that we looked at that were awarded non-competitively did not have a good justification on file.
Thank you for that. Now, referring to your previous work on Arrive scam as well, since GC Strategies was allowed to sit at the table and negotiate the terms of its own contract as well, can you confirm, although I am hearing it in the response you gave to my last question, that this is happening frequently across departments? Would you say that this is happening frequently across departments?
I guess I want to draw a distinction between what we saw in ArriveCan and what we're seeing here. In ArriveCan, we clearly saw that GC Strategies was involved in setting the selection criteria. We did not see that in the McKinsey contracts. We saw that at times when there were competitive bids run, that the criteria, the selection criteria, weren't always used, but not that McKinsey had been involved in setting the selection criteria. So they're very different situations.
So then, given that, in your opinion, what specifically needs to be changed? What changes need to be made to ensure Canada's procurement processes are truly competitive?
When it comes to competitive contracts, what we found is that often there was, I think it was about more than a third of the time, the bid evaluation didn't have selection criteria that were clearly outlined, or when there were selection criteria, they weren't used. It's clear in the rules that you need to set out these criteria, and then you need to have a good evaluation grid and a committee put together. So again, to make this competitive process fair and transparent, the existing rules should have been applied.
Looking at your nearly closing statement, you said the remedy isn't necessarily about creating new processes or rules, but rather about understanding how these processes and rules are applied and why often they're not. Can you expand on that one?
Mm-hmm. Well, I think over time, whenever there's an audit done, whether it be by an internal audit department, the Comptroller General's office, the Procurement Ombuds, or my office, the tendency is to add more rules. And I think here the case was not that there were rules that were missing, except for conflict of interest, which is why we issued one there, but that the rules just need to be followed. And I think it's important for the federal government to sit back and try and assess why this is happening. What is it about the procurement rules that are driving the behavior that we're seeing? There are many reasons that could be there. Is it that the rules are so complex in order to speed up the procurement process? People are working around the rules? Is it that there are so many rules that they don't know them all and are accidentally not applying it? Or is there some other behavior that is driving what we're seeing? Because it's clear that the rules are there to ensure fairness, transparency, and accountability and delivering value for money. It's just they're not being followed.
So, thank you. That was a great coverage with. Can you tell me, in your opinion, do you think those rules, because I'm sure you've looked at it, do you think those rules are complicated? Because you're clearly saying, let's not add more rules to it, which we really support, because we are doing a study and my colleagues are going to follow up on that. But do you think our rules are complicated?
I think there are a lot of rules, and at times they can be complicated. And I think there was a recent announcement by the Treasury Board about adding certain certifications around procurement processes, and I appreciate that additional layer that was added. It wasn't about adding a rule, but about reminding people to certify that they have done certain things in the rules. I would tell you there is some confusion. If we look at the National Master Standing Offer, I think most organizations believed that because they had to use the standing offer, that they could just pull off of it. But what's clear is that that is just an offer of goods and services. It isn't a contract. So when you create a contract that is done in a non-competitive way, the rules kick in that say you should justify why. And often that justification was lacking. So I think there it was that folks didn't understand necessarily what the rules were. So I think it's a bit of both. There's a lot, they're complex, and they're not always easy to follow.
What's at stake here is value for money. This is Canadians' money. It's being spent poorly. There's one company that's enriching itself to the tune of millions and millions of dollars. There are individuals that make a decision to break the rules, and whether they know the rules exist or not, there's still some culpability there. How do we ensure that people are held accountable, and where does accountability ultimately fall in this place?
You have about 5 seconds for an answer.
I've said it before. I think ultimately accountability rests with the deputy head or the head of a crown corporation to make sure that all of their contracting provides value for money.
In your audit, you found multiple instances of favoritism being shown to McKinsey. In one instance, the Business Development Bank of Canada gave a contract to McKinsey, despite McKinsey not being the highest scoring bid. They also gave 2 sole source contracts without documenting their justification, and my colleague mentioned that in her intervention. And the Canada Border Services Agency had 3 contracts missing bid evaluation documents, and Innovation, Science and Economic Development Canada had 2 contracts missing bid evaluation documents. And as my colleagues have been pointing out around the table this morning, we see repeated abuses of the procurement system with seemingly no checks and balances in place from the government. And it would appear no concern or pushback as well. If the exception becomes the rule, then I believe this becomes the culture and that we have a huge problem within the government. How is this allowed to happen with no consequences for those who are failing to follow the rules?
I do agree that when 70% of the contracts awarded were done so in a non-competitive way, it raises concern competition should be the default. Competition ensures that you hopefully get a better price for taxpayers. I guess that doesn't always mean that it is the lowest bidder. There could be business reasons that you might choose a different bidder, but again, I would expect that kind of a judgment call is well supported and documented. I think often that's what we're missing here, is that the rules aren't being followed, and then there is no demonstration for what business decision drove that. And I would really like to see everyone across the federal government sort of have more rigor in their procurement processes. This isn't a big burden that we're asking. It is about just being transparent and being able to answer to Canadians 10 or 12 years down the line why a decision was made. And it starts with understanding the rules and then documenting all of the judgment calls that are made along the way.
I want to confirm what I believe I heard you say in regards to accountability, and that there needs to be accountability within a department, regardless of whether a department head, a deputy minister, an assistant deputy minister, any one of those individuals were involved in the procurement, that they need to be held accountable for decisions that are made within their department and when rules are not being followed. Is that what I heard you say?
I believe that Andrew's going to want to jump in here, but I think I would start off by saying that legislation makes it clear that the deputy head's the accounting officer of an organization, and while you might delegate those powers to others in the organization for day-to-day to happen, because, for example, I couldn't review every single contract that my office issues, but you still have to make sure that people are properly trained, they understand the rules, and there's good compliance and overview. So I don't know, Andrew, if you want to add something?
The only thing I would add is that we stressed in our ArriveCan report the importance of delegated decision makers understanding and being accountable for the decisions that they make to spend public money. So as much as the deputy head is the responsible person to answer and be accountable here at committee and before Parliament, there is an accountability all the way through the organization that should be enforced.
And I'm not sure how much time I have, but I would ask, does being moved out of a position sever the responsibility that you might hold when you were in that position making decisions?
I mean, my view is not. I would expect, however, that you left a really good file behind to demonstrate the judgment calls and the decisions that you made. People's memories are going to fail, and so it's important to make sure you document something when you're going through it.
Inside your report, you talked about the chains of non-competitive contracts. Can you explain the what that means, the chains of non-competitive contracts, and what are the risks specifically to these chains of contracts?
Mm-hmm. So I think I just want to be clear that that's a word we described. We didn't know a better way to describe what we were seeing. It isn't a term commonly used. For me, what it shows is that if you issue the first contract in a competitive way and then issue subsequent contracts in a non-competitive way, you're limiting competition. As I said, the default of competition to drive better value for money is important. More concerning is the chain of contracts where the first contract is a small contract that called on an exception under the contracting rules, that if it's under a certain dollar threshold, there was no need for competition, it wouldn't provide better value for money. But then to use the subsequent exception for the follow-on contracts that were of a larger dollar value in the millions of dollars, again, starts to question, did you not think at the beginning what your need was that you needed to fill? It comes down to that fundamental starting question, but constantly says, well, are you then more dependent or creating a dependency on a vendor if you're issuing multiple non-competitive contracts, and how are you ensuring best value for money if none of them are being competed? So I think it brings in so many rules when we see the chains, which just raised a lot of concerns for us.
It seems possibly defensible that some people within specific departments might not be familiar with all of the procurement rules, but you would think that the department that is solely responsible for procurement would know all of the rules and would be able to challenge the departments when they see those rules being flagrantly broken. Like, is PSPC not living up to its purported reason for being? Like, this is the whole model that we have, and it doesn't seem to be working.
So I mean, we did find in this audit that they could have done a better job at challenging many of the organizations, especially when there was multiple contracts that appeared to be issued for similar work in a really short period of time. But there are things that they're not aware of. So I am, as I mentioned earlier, if a contract's issued below a dollar value threshold, it's only the department that issued that contract would be aware of it. There is no big central repository for all of that information. But when it comes to the National Master Standing Offer, let's look at that, for example. I believe the Deputy Minister has been before committee before, testifying on how she didn't believe that the call-ups required a documentation. I think I had a very lengthy conversation with her about, but the National Master Standing Offer is just an offer. It's not the contract. So when the contract happens, it should be required. I think following the Procurement Ombud's work, she actually changed the requirements and now is reminding every department that they should provide that justification. So I think this is a learning opportunity as certain tools are used more often, that rigor needs to be put into documenting decisions.
Thank you, Chair. So we're here looking at the government's cozy relationship with McKinsey, and thank you again to the Auditor General for your excellent work exposing significant problems, $200 million in contracts that have gone to McKinsey under this government, most of which in some way or another did not adhere to the rules. You've just mentioned the important role that PSPC, the government's contracting department, is supposed to play, could have played, challenging some of these procurements. In that light, I think it's interesting to note that the Director of Policy to the Minister of Public Services and Procurement, Mr. Boyan Gerasimov, he had this critical role of Director of Policy in the Minister of Public Services and Procurement's office during the critical period of the pandemic from March 2020 until December 2021. He is McKinsey alum. He served with McKinsey for more than 5 years as an engagement manager, went from working with McKinsey into this Liberal government in an important senior staff role. His LinkedIn specifically cites work he did in relation to major defense equipment procurements. So you have former McKinsey in this critical role in government procurement in the Minister of Procurement's office under then Minister Anita Anand, a former McKinsey employee, and you've highlighted that the government's contracting department that he was working for could have provided a greater challenge function, and they didn't. And we've also seen how the Defense Department in particular had a very close, extensive relationship with McKinsey. So this is quite concerning to me, and it underlines the close relationships that exist between McKinsey and this Liberal government. I wonder if you could share a bit more about what role the minister's office did play or could have played, providing a challenge function around this extensive procurement relationship that emerged, and what conclusions we might be able to draw about the role that the Director of Policy in Minister Anand's office should have been playing, could have been playing, did play in relation to these procurements.
So typically, I would not expect ministers to be involved at all in procurement decisions that are made by departments. And when we looked at these 97 contracts, we did not see ministerial involvement except for one where it was required by the rules. I would expect that PSPC would do a better challenge function in some of these contracts. In other areas, we saw that they did do a good challenge function. I think ultimately it boils down to making sure that everyone who's involved in the procurement process understands the rules and applies them in a way to ensure fairness, transparency, and good value for money for Canadians.
So the function of the minister's office is to set a policy framework, and the Director of Policy plays a key role in that. You're saying you wouldn't want to see them involved in kind of micro procurement decisions, but I guess for them to have a function at all, presumably it's to set that policy framework in which says how sharply they're going to exercise that challenge function or not. And there clearly were failures to challenge McKinsey procurement in cases where it should have been challenged from that department. Is that correct?
For sure. I think that PSPC should have done a better job at challenging some of the procurements that were brought to them for them to be able to issue contracts. But I would expect that challenge function also exists in every department and agency, because not all contracts go through PSPC in order to be issued.
Right. No, and I think there are problems in other places for sure, but it stuck out to me that this particular person, Boyan Gerasimov, was the Director of Policy to the Minister of Procurement in the middle of the pandemic, and that he is a McKinsey alum. Madam Auditor, just in the time I have left, I note in your report 45% of the contracts examined lacked sufficient documentation to justify the need for a contract. So in almost half of the cases of these contracts, there wasn't even evidence or sufficient evidence that there was any reason for the contract to happen in the first place, which is quite staggering in light of $200 million in contracts. Anything more you can share about that 45% figure and what it reveals?
Well, for me, it reveals that at the start, everyone should be taking a step back before they enter into a procurement process. You need to figure out if you are trying to fill a skills gap that doesn't exist in the public service, whether you need additional resources, or if you're just trying to get, plurality of thought and trying to get something outside the public service to compare to. Once you've justified that, then you make an estimate for what you think you're willing to spend for that. Those are all requirements that are in the procurement policies that exist now, and then go out and get a contract. I would expect that the default would be competitive unless there's a justification for non-competitive.
Thank you very much.
I'm going to preface my questions with a comment. And since you released your reports, three reports last week, I've heard from hundreds of Canadians who have expressed their profound disappointment in this NDP Liberal government that over the course of almost 9 years consistently demonstrate a lack of adherence to basic procurement rules. And to your point in this particular audit is you focus in on whether or not procurement, in this case to McKinsey, provided value for money for Canadians. And I take a look at your overall message, and you indicate quite clearly that federal contracting and procurement policies exist to ensure fairness, transparency, and value for Canadians, but they only work if they are followed. So I'm hearing that, yes, the auditor is making recommendations, and the department heads and organizations are saying, yes, we'll agree to follow those recommendations. But they already know what the rules are, and they're not following it. And every audit that I have been privy to from your office consistently shows a pattern of disrespect for taxpayer monies. So the question to you is, how do you define value for money from an auditor's perspective?
So that's not always a simple question to answer. In this case, we did outline in our audit report, I'm just trying to find the paragraph for you, it's paragraph 28, where we listed elements that we were searching for to demonstrate value for money. I would have told you that value for money during the pandemic might have been evaluated in a slightly different way than it should be evaluated in the normal course of business. But we would have expected that departments would have clearly articulated the need for a contract, what the expected deliverables were, whether all the deliverables had been provided, and whether or not the ultimate intent of that contract, so the outcome, was achieved. So we more than half, one or more of those, we could not see being demonstrated.
The Government of Canada has published on its website that it must adhere to 4 fundamental principles of financial management. 1, value for money. 2, accountability. 3, transparency. And 4, risk management. Government of Canada defines value for money as follows: that public funds, taxpayer monies, are managed with prudence and probity. Assets are safeguarded and resources are used effectively, efficiently, and economically to achieve departmental and governmental objectives. A very specific definition. So, I know that you've indicated last week that your mandate, and you've indicated this numerous times, your mandate is also to refer criminality, should you suspect criminality, to the appropriate authorities. And I believe you indicated when a question was put to you whether you discovered any element of criminality. I want to confirm a couple of things. Your threshold for referrals is based on suspicion and suspicion only. Is that correct?
I mean, it is very rare that we would refer something to the RCMP or to law enforcement before our work is made public. But we're always happy to talk to the RCMP once it's out there. But we have not made a referral in this case.
Do you agree that the Government of Canada holds its position as a trustee over public funds? Do you agree with that statement?
That it holds its position?
That it performs the role as a trustee over public funds. Do you agree with that statement?
I agree that it should be using public funds in a way that brings the best value to Canadians. Okay. Absolutely.
You don't agree that they hold a trust relationship with Canadians?
Well, absolutely. Every individual should trust its government.
Sure. Mm-hmm. Which brings me to a potential criminal charge of breach of trust under Section 336 of the Criminal Code, a straight indictable offense punishable by a maximum of 14 years. The elements are there that potentially someone who made the decision to favor McKinsey on a broad range of departments and Crown corporations could be held liable for the actions that they took. So, did you direct your mind at all to the potential that there should be a breach of trust investigation by appropriate law enforcement?
Very brief answer.
Given the origin of this audit, we were looking for whether or not there was direction or political interference. We did not see it in this audit. If there was, a concern around improper use of public funds in a way that could have been criminal, we would have referred it to the RCMP.
I'm afraid that is our
Position of
time, Mr.
authority,
Brock.
though?
That is our time, I'm afraid.
And just to, along those same lines of what my colleague had stated, we are absolutely always concerned about making sure that public funds are used appropriately, which is why we were so disappointed that the Conservative Party was using tens of millions, if not hundreds of millions of dollars of public funds for political events to pay for the travel of themselves and their spouses to political caucuses, which everyone knows is absolutely wrong. So I just wanted to get that on the record. Ms. Hogan, we know how important the independence of your office is to do your work. And we know that it's important. This allows your work to move forward unimpeded. Last week, the Conservatives put forward a motion requiring your office to produce documents in your possession. And so I wanted to ask you, how does ordering your office to do this impact your ability to fulfill your mandate and conduct your audits?
So I believe that the member, Mr. Chair, is referring to the motion in the House that is, I think, being voted on later on today. In my view, in my opinion, including my office in that motion was unnecessary. I made it clear last week that I would cooperate with the RCMP if they felt it necessary to come to my office and ask for information. We have a well-established procedure that has worked effectively in the past, which includes them providing me with a production order should they want to have access to my files. I believe that the motion does impede on my independence in that I don't need to go through the law clerk. I have a proven track record that I am cooperative and supportive with parliamentarians, and that I would cooperate very swiftly with the RCMP if the need arose.
Like I find it a bit bewildering that these are individuals, some of whom are paid hundreds of thousands of dollars to ensure that the public gets value for money and that all the rules are followed, and they need a checklist to make sure that they didn't skip any steps. And it seems like they're not even aware the steps exist. If the fix is so simple as a simple checklist, why wasn't this done years and years ago?
Well, the comment I made is one that actually was just implemented, I believe, by Public Service and Procurement Canada or from Treasury Board. It was actually from Treasury Board. It was an announcement that those were some of the strengths brought to the procurement process. And I think that just reflects on the complexity of all of the rules that exist. There are many, it's not just Treasury Board policies, there's trade agreements, there are so many things that need to be factored in to a procurement process. That it does require at times, I think, a bit of an aide-mémoire, especially if it's not something that you do every day. And that's why I would encourage every organization to make sure they involve their own procurement branch in addition to Public Service and Procurement Canada if needed.
I'm going to go back to the National Master Standing Offers. So a National Master Standing Offer was granted to McKinsey in 2021 in a non-competitive process. This was not properly justified and ended up costing a total of $42.4 million. The call-ups issued under the unjustified offer were also unjustified. How does the justification process need to be reformed to ensure competitive processes are honored?
I think one point to clarify here is that the National Master Standing Offer was done in a non-competitive way. While Public Service and Procurement Canada provided a justification, we felt it was rather weak. Then the next step is where I think confusion existed when there were 19 call-ups against the National Master Standing Offer. I think the organizations felt that they were using a procurement vehicle that was at their disposal and that they didn't need to justify why they were using that vehicle. But when you realize that that is the first time a contract is being issued between the government and McKinsey, the non-competitive contracting rules kick in, and there should have been a well-documented rationale for why that National Master Standing Offer versus another.
In your opinion, why do you think some departments are capable of contracting according to government standards, but according to government standards. But Procurement Canada, the body in charge of procurement, seems to struggle in this area.
I think Public Service and Procurement Canada issue many contracts. They were not involved in all 97 here, but what we found is that they could have done a better job challenging. And I think that's one of the big questions that the public service needs to ask itself is, what is it about the rules that's causing this behavior? Because the rules, in my view, are rather clear. While there are many, they are rather clear.
Clearly, it's the government. Why was a minister's signature required for a $5 million contract, but not any of the other of the massive contracts, that were granted to McKinsey?
In the case where the minister was involved, the contract was being issued on a non-competitive basis, and there's a certain threshold that the public service can no longer authorize a non-competitive contract. I think it's $4.5 million. And that's why a minister needed to be involved, because it was non-competitive versus competitive.
The justification provided was challenged by procurement officials before the minister signed off and agreed to the call-up. Is it concerning that a minister personally signed a contract that her own officials challenged? Have you seen this elsewhere?
I'm going to see if Nick wants to add something here, but it's my understanding that the minister did not actually sign the contract. They just provided authority to exceed the limit allowed by the public service. He's nodding in agreement.
That's great.
So.
I'll turn to contract chains now. A practice you discovered is that a small non-competitive contract would be granted to a department as it fell below the threshold that requires a competitive process. Once this contract was awarded, departments would argue that future contracts had to be done through McKinsey as they had already begun the work. How common is this practice across government departments?
I don't think I can answer how common it is across all of government departments. We saw in this case, out of the 97 contracts, 4 chains. Those 4 chains involved 30 of the 97 contracts, but I'm not sure that can be extrapolated across all government contracts.
Should small contracts have rules about future contracting, in your opinion?
I think then it comes back down to what was supposed to be the bigger, broader procurement process. It comes back to that initial question of what was the need that you were trying to meet, or what service were you trying to get, and then figuring out the right procurement process. I believe that the way these chains were structured did not favor value for money and likely limited competition. I believe that if you give Andrew a couple seconds, he might like to add something.
I would just add that it doesn't make sense to us that a small dollar value contract would be the basis upon which you could exercise a future justification for non-competitive. For example, that it's not in the public interest to compete it when it's only been a minor, small amount of investment at that point in time.
So there's nothing in place currently that prevents these types of contracting chains?
We would consider those kind of justifications to be weak. They shouldn't be the reason for proceeding with a non-competitive contract in those cases. The rules are clear, but the application is where it falls down.
Thank you.
And I think it's important to state that this is not something new, right? This is not something that's been unique, because you've had a number of opportunities to review procurement, review the status of some of the work that's being done across the board, not just with McKinsey, and you've made some great recommendations thus far. Has the government adopted your recommendations that you've made up to this point?
I mean, if you're talking over the years that my office has done procurement audits, absolutely, they have adopted them. In this case, I only issued one recommendation because I felt that the procurement ombuds and the Controller General and the internal audit shops, who had done work from March of 2023 until very recently, had addressed all of the other concerns. But again, I just want to reiterate, I don't think it's about creating more rules. I think it's about understanding the existing rules and why they're not being applied.
Thank you, Chair. To be really clear, this report was initiated by the revelation of the sudden sharp increase of contracts that McKinsey received once this Liberal government took power. And I'll reiterate, from 2011 to 2015, McKinsey received $8.6 million in contracts From 2015 onwards, under this Liberal government, they received $191 million, a much higher number than was previously reported. So while I agree that it is perhaps a bellwether of what is happening across departments writ large when it comes to a blatant disregard for the rules when it comes to contracting, we did see a very sharp increase in contracts to one individual company. Prior to this audit, we found there was a personal connection between McKinsey and the Liberals. In fact, it was Dominic Barton, the head of McKinsey, who was the brain behind the creation of the Canada Infrastructure Bank. You found in your audit that the Canada Infrastructure Bank gave 2 contracts to McKinsey with no evaluation criteria in the request for bids or in those evaluations. Did the Canada Infrastructure Bank have any explanation for this?
I'm going to have to ask Nick if he can provide some additional details on that.
So the scenarios they were working with was that so this gets a bit complicated. Sometimes in RFPs and so on, you have there are provisions that they don't necessarily have to follow very precisely the evaluation structure that they set up, and so that was the case with these ones in the competitive realm. Our concern was that this was not well documented.
Thank you very much. You also raised some serious privacy and security concerns in your audit. You found that in one case, IRCC gave 5 contractors access to their network without the proper security clearances. What sort of information would these contractors have had access to on IRCC's network? Would this have included sensitive personal information of Canadians? And then what other instances were there of contractors doing work or being given access to sensitive information without the proper security clearances? Were there other departments?
So when it came to the issue with Immigration, Refugee and Citizenship Canada, I actually spoke with the Deputy Minister myself. He assured me that the individuals in question didn't access anyone's personal information. I would have been concerned around applications from individuals seeking either residency or work permits here in Canada. When we looked at the security, we found that in the contracts that we sampled, there was 17 that required security clearances in order for the work to be done, recognizing that this is only in the contracts from the departments and agencies, because that's where the government security policy kicks in. We found that about 76% of them couldn't demonstrate to us that the individuals who were going to do the work had the required clearances before that work began. So that is very concerning. It doesn't mean they didn't have a clearance, but what it means is that the individuals managing the procurement process did not have that on file and had not done that work, and that is a requirement. That is an important rule that really should have been followed.
Given the perception that this was done to avoid a more rigorous procurement process and more rigorous rules, what can be done in order to prevent that from happening? Assuming that the more rigorous process is in the public interest, I'm wondering if the steps the government has taken to strengthen procurement address this specific situation that you've raised here.
I can tell you that I spoke with both the head of CDEV and the Deputy Minister of Finance about this situation specifically, and some of our concerns were that the Department of Finance should have been further withdrawn. They didn't need to provide the statement of work. They didn't need to go get a contract to get advice. They could have said, we need advice in a certain topic, can you provide it to us? And then leave the Crown to determine the best way to get access to that. So it's that perception of being a little more involved that is the one that we questioned here.
Thank you.
Thanks, Mr. Backrack. Mr. Genwes for 5, please.
Thank you, Chair. Madam Auditor General, again, just kind of summarizing your report here on McKinsey contracting with this this current NDP Liberal government, your frustration seems to kind of exude through the pages in a few ways. I note, for instance, on the recommendation side, you basically said, well, many of the recommendations you've made on previous reports would have relevance to this report, so you're not going to repeat them. Fixing the problems is a simple matter of adhering to the rules, and you note that it's not complicated. There are rules in place. The rules are just not being followed. And it highlights the fact that pointing out the problems is one thing, but the government has to actually be serious about implementing the solutions. And I guess it's frustrating for me to hear the discourse in response to your reports is always very, very deferential publicly from the government, saying, "Oh, we listened, we thank the Auditor General for her work, etc." But then there is a failure to implement the basic solutions, and we have a situation where you have a report coming back saying essentially, I don't need to repeat myself, refer to previous reports for recommendations that would have addressed many of these problems. What can be done to get at this core issue of maybe governments paying lip service to recommendations you've made, but then not taking their implementation seriously?
So just a small point of clarification in this report, I wasn't referring to our previous recommendations, but those that the procurement ombuds had just recently issued, as well as the internal audit departments and the Controller General. So when it comes to following the recommendations that we give and actually implementing them, I wish I had the solution, because we often hear, yes, we agree, and then don't see action. But I have to say, following ArriveCan and throughout this audit, we saw that Treasury Board and Public Service and Procurement Canada were already making changes. So that's a positive. What I'm hoping we'll see going forward is that it isn't just a one and done, that there is a recognition that the reminder about procurement rules should happen on a regular basis. And that's why I do believe that every organization needs to make sure that they have better monitoring or better quality control system over all of this. Because while the rules may be confusing at times, they are very clear, and it's how they're applied and then well documented that should be improved.
Yeah. Yeah, it is frustrating, I think, to many Canadians that after 9 years of this government, the simple matter of you've got to follow the rules and the rules aren't being followed, and where improvement is characterized as, okay, well, we're going to work harder to follow the existing rules. We're not even talking about existing rules being inadequate. We're talking about a failure to adhere to rules. In the time I have left, I am going to pass it over to Ms. Kusi. Thanks.
Again, I think given this damning report, Mr. Chair, I'm going to launch into a motion that I've submitted to the clerk. The motion reads as follows: that in relation to the committee's study of government contracting with McKinsey, the committee invites Dominique Barton, former global managing partner of McKinsey; Bob Sternfels, current global managing partner of McKinsey; Boyan Gerasimov, former engagement manager of McKinsey and former director of policy to the Minister of Public Services and Procurement Canada; the McKinsey Canada officials responsible for securing government contracts; the President of the Treasury Board and Department officials; the Minister of Public Service and Procurement and Department officials; Department of National Defence officials; Department of Immigration officials; Business Development Bank of Canada officials; Export Development Canada officials; Public Sector Pension Investment Board officials; Trans Mountain Corporation executives, Mr. Chair; and finally, Canada Infrastructure Bank officials. So, as I said, Mr. Chair, we have just seen a damning report delivered by the Auditor General here this last week, and we must uncover more. Even she did not have the answers for us today. Even she said that we need to have more information in an effort to really solve both the incompetence as well as further explore the cozy relationship between the Liberal government and McKinsey. We need to get to the bottom of this, and so with that, I am putting forward this motion today. I am moving this motion today, which calls these witnesses in an effort to do that, Mr. Chair. Thank you very much. Merci beaucoup.